Hello everyone. I hope this message finds you fit and fine. My name is Shashank and I welcome you all to our Indian Polity series based on Lakshmikant with the name Kanthasth. Now consider this is a contract. Contract we entered. It means me and you made this contract. Okay. In the first lecture on making of Indian Constitution, I discussed social contract as a concept on which our constitution is based, right? Now, what is the meaning of contract? It means some terms and conditions are mentioned and why we both entered into this contract so that some meaningful achievements can be made, right? Now, consider after 2 years. So, this contract is for say 100 years, okay? Now, after 2 years, would you like this contract to be reviewed and amended? You would say it depends. If it amended for betterment, then why not, right? But would you like this particular contract be amended by which you actually are going to suffer some loss? Obviously, you would say, no, why would I accept that, right? Now, when we talk about Indian Constitution, it is a social contract in which we people of India give ourselves this Indian state, and we talked about certain key principles on which India is based, right? Now, after say 70 years, a need emerged. Let's change this contract, this particular article in this contract for the betterment. So, we all are happy with that. But if it is changed in a manner that our rights are taken away, then I hope you will say, no, we are not going to agree on that. But whether you will be agree or whether you will not be agreeing depends on your awareness, how this change is going to impact you. And this is the biggest dilemma in polities across the world, that people are not aware how change in law is going to impact their life, right? So since you are not aware, then who is going to be, safeguarding your interest? So in this case, it is Honorable Supreme Court. Now, my friends, I hope you got the idea, the amendment part of a contract. Now, to safeguard this, Supreme Court invented a concept, basic structure. Supreme Court said, okay, Parliament, you have the people who are representative of, people, right? These representatives are representing the people, right? People's will. So you can amend Indian Constitution, but you cannot amend Indian Constitution in terms of changing the basic structure. Otherwise, it would be like you are rewriting the Constitution of India, right? So that's why this basic structure word emerged. Please remember, the basic structure word is not mentioned, defined in Indian Constitution. It is not mentioned. It is an outcome of judicial creativity. It was first pronounced in a very solid manner in Kesavananda Bharati case, 1973. Now, some of you might say, sir, you said in forced solid manner. What does it mean? It means that although the basic structure as a word, its applicability was clearly defined in Kesavananda Bharati case, but the background of basic structure doctrine was actually getting built through different cases in the past. We are going to discuss those cases in today's video. Okay? Now, I'm making a statement and you have to tell me whether the statement is true or false. Okay? And I have no expectations from you as of now. Now, statement is, basic structure of Indian Constitution can be defined by, okay, it means who can actually declare that this is going to be the basic structure of Indian Constitution. So, statement 1, Supreme Court. Statement 2 means option 2, Supreme Court as well as Parliament. Third, Parliament only. So now tell me, which of the following you think is correct option? First, I said Supreme Court. Second, I said Supreme Court and Parliament. Third, I said only Parliament. Now tell me. And your responses should be registered in comments. So some of you might be thinking that it is about defining what is going to be the basic structure. And it should be the job of Supreme Court, because Supreme Court is the ultimate interpreter of Indian Constitution. Parliament is not the interpreter of Indian Constitution. Parliament can amend. Parliament can make use of the provisions of Indian Constitution. But Supreme Court is the interpreter. Yes, and that is why answer is A. Okay, so you need not to be confused. Oh, we are talking about this defining feature. So it may be possible that at some point of time, Parliament also make a law says that this is going to be the basic structure. No, no confusion in this case. Okay, now, and do you have some a particular document that which is going to tell you that these are the basic structures of Indian Constitution? So we don't have any such document. And you should know this basic structure doctrine is not applicable just in India. Many countries, many apex courts across the world have adopted this doctrine to safeguard the basic features of their constitution. For example, even Pakistan has this basic structure doctrine. Malaysia has, Bangladesh has. Okay, and there's uniqueness in Bangladesh constitution that they have this Article 7B. And in this Article 7B, they have clearly documented what is going to be the basic structure of their constitution, which need not to be amended by any government. But our Supreme Court has not done this kind of interpretation. Can anyone tell me why? Why our Supreme Court has kept it open-ended, subject to interpretations in different cases? Why? My friends, the rationale was that if we make a box that these are going to be the basic features, then in this case, what is going to happen? Parliament in future might find ways to amend constitution beyond these, right? Beyond this. And Supreme Court did not wanted to limit its scope to review whether this amendment is going to impact basic structure or not. And that is why it was made open-ended. Although time to time it has been defined, and we have now more than 20 features as basic features of Indian Constitution. Okay? Now, there's another interesting debate from basic structure of Indian Constitution, because UPSC might ask you that discuss the evolution of basic structure doctrine in Indian polity. So if the question statement says discuss, so it means they want to know your understanding of basic structure doctrine and how it is evolved. It has evolved in Indian polity, right? You can mention that Shankari Prasad case, Sajjan Singh case, Golaknath case, Kesavananda Bharati case. You can mention that trajectory and what are the different features we have. You can mention some as example, and in the conclusion you can mention what is its utility. Job is done. But if UPSC uses the word critically analyze the evolution of basic structure doctrine in Indian polity, now tell me what you are going to do now. Critically analyze. So my friends, your understanding of a particular chapter in Indian polity should not be based on what is basic structure doctrine. It should not be based just on provisions or cases, what they are saying. No, you have to get into merit list, and for that, after prelims, you have to clear mains, and then you have to supplement, show your understanding in interview when such questions are asked. So what needs to be done? In critical analyze part, you should be having understanding about the innate debates. Okay, and that's not quite difficult actually. Because beauty of polity is that everything is logically connected to each other, right? Now, so I ask you why this basic structure doctrine means critically analyze part. What you are going to do? Just let's go into the story, and within story you will find the answer how critically analyze part need to be answered. So this is our preamble, and it is considered that this is going to be the guiding light which is going to be used by Supreme Court to ascertain whether this particular issue or this particular feature is part of basic structure or not. Now, emergence of the basic structure doctrine. Now, from where this debate emerged? So it started with fundamental rights amendability, and this started just after 1 year of the enactment of Indian Constitution, as Jawaharlal Nehru government wanted to bring this land reforms. And if you want to bring land reforms, then these land reforms are going to hamper two fundamental rights. It means fundamental right is one, but that is mentioned in two places in Part 3 of Indian Constitution. I am talking about right to property, mentioned in Article 19, was mentioned in Article 19 as well as Article 31 at that point of time. Now, so basic structure doctrine was not there at this point of time. We are talking about 1951. So the question started whether Parliament can make such a law which is going to hamper fundamental right and still that is going to be considered as legal, as constitutional. So from this point, this debate started. Okay, so whether using the power under Article 368, Parliament can amend any part, any provision of Indian Constitution, right? So this was the question which started within 1951. Now, in the backdrop of this question came Shankari Prasad case. In Shankari Prasad case, the very question was raised before the bench of Supreme Court. Now, interestingly, Shankari Prasad case said the power of judicial review with respect to fundamental right is coming from Article 13. We discussed Article 13. What Article 13 says? Any law which abridges any provision mentioned or fundamental right mentioned in Part 3 will be declared as void, right? But the point was, Shankari Prasad case said that the definition of law does not mean Constitutional Amendment Act. It does not mean Constitutional Amendment Act because the definition of law meant rule, regulation, laws made by Parliament. It means ordinary law will be considered under legislative power. This categorization was used by Supreme Court. Legislative power. In this case, when a matter of ordinary law is going to abridge any fundamental right, there, yes, Supreme Court can intervene using Article 13 and declare that law is null and void. But in this case, they said, with respect to Constitution Amendment Act, we should know that this is constituent power. Means this is about amending the Constitution itself. So there's a difference between constituent power and legislative power. So Article 13 won't be applicable on constituent power of Parliament. It will be applicable on legislative power, and that is why Parliament can amend fundamental rights. This is what Shankari Prasad case declared. Okay, Supreme Court declared in this particular case. So government amending Constitution give effect to directions, and what directions we are talking about? Directions in DPSP, because I told you land reforms, this law was taking inspiration from Article 39B, 39C, which were talking about that government should take such step, right? Now, first case challenging amendment power of Constitution, judicial response was no limitation. So, response was no limitation. But why that response? Because of this logic which was given by Supreme Court. Okay, I hope you are clear with the judgment. There is no limitation. Fundamental rights can be amended by Parliament, and the logic also is clear to you, right? Now, the constitutional validity of First Amendment Act, which curtailed the right to property, was challenged, right? Law, ordinary law, not constitutional amendment. I have just explained this to you. Supreme Court ruled that power of the Parliament to amend the Constitution under 368 also include the power to amend fundamental rights. I have just explained this to you, right? Now, before we go to Golaknath case, an interesting case happened before Golaknath case. We are talking about 1964. 1964. And why I'm talking about interesting? Because I see root of basic structure doctrine here. I'm talking about Sajjan Singh case. So within Sajjan Singh case also, the matter came in favor of government, or you can say parliament, that yes, amendment can be done. Fundamental rights can be amended, right? But in Sajjan Singh case, Justice Mudholkar, he actually presented his dissent. Means he was not agreeing, means he was not totally agreeing the way the powers were given to parliament, okay? But he was in dissent, but his judgment was not having that much power because majority of the bench was in favor of yes, this power belongs to parliament. My question is, why he was showing this dissent? Why? So he asked a question, and this question became very popular at that point of time. He asked this question, that when it comes to amending power of parliament, whether basic features can be amended, because if you amend basic features using Article 368, it will mean that Parliament can actually rewrite this constitution. So, in his observation, he created a differentiation for other judges to look into. He said, one thing is amendment, that yes, there was a need, and that's why you have added, you have subtracted, or you have altered some language in Indian Constitution. That is amendment. But if you are changing the basic features, the basic foundation, the basic idea of Indian Constitution, then it will be like you are rewriting the Constitution. So can Article 368 be considered as rewriting of Indian Constitution? Because at that point of time, the title of Article 368 was Procedure of Amending the Indian Constitution. It was not like power to amend Indian Constitution. It was later amended by Indira Gandhi government, and they changed the title that power for amending Indian Constitution. We are going to come to that. But the point is, he raised this question. And this question, which was raised, became the seed of basic structure doctrine. Okay? Now later, Golaknath case. So there's a twist came into Indian polity's story, that now before Golaknath case, judiciary was giving favorable judgment in favor of parliament. Yes, you have the power. But in Golaknath case, they took opposite stand. What they said? Parliament cannot take away, abridge any fundamental right. Now story of amending fundamental right is over. You cannot amend. Fundamental rights cannot be amended for implementation of DPSPs. It means, in this case, FRs were given priority over DPSPs. And we discussed this when we were discussing about the debate, the conflict between FR and DPSPs when I took this chapter DPSPs, right? So they gave in favor of FRs. Now Parliament reacted. So because you have actually limited the power of Parliament, the Parliament cannot amend fundamental right. So now Parliament resolved, okay, so this is your interpretation of Parliament, this is your interpretation of Indian Constitution. Supreme Court said, yes, this is our interpretation and we are the ultimate interpreter. Then Parliament said, but we are the one who have the power of amending the Constitution. So we are now amending the Constitution, and just take a look, read, and then interpret. So they did this 24th Amendment Act and 25th Amendment Act. For example, in 24th Amendment Act, what they did, Parliament has the power to abridge, take away any of the fundamental rights by enacting Constitutional Amendment Act 368. It means they amended the Article 368 itself. And there they clearly mentioned that Parliament has power to amend fundamental rights. Now, the ball was in court of Supreme Court. And if Supreme Court has to read this and interpret this, because Supreme Court cannot change, Supreme Court has to read, right? So, means at that point of Parliament was thinking they cannot change, they can only read. So, Parliament has the power to abridge and take away any of the fundamental right, any. So, it was like power is now in the hands of Parliament because Constitution is saying that. Now came Kesavananda Bharati case, and in Kesavananda Bharati case, they pronounced this basic structure doctrine. And when Parliament asked, what is basic structure doctrine? Then Supreme Court said, we are going to decide on case-to-case basis. What you need to know is that you were saying that you have ultimate amending power of Indian Constitution. Yes, you have. Be happy. But you cannot amend the basic structure. And we are going to decide what is the basic structure. So balance sanctity of Indian Constitution and need to further goals of social reform. Means on these logic, we can have a balance. Certain amendments can be considered as justified. But my friends, this Kesavananda Bharati case judgment was pronounced not on the basis of that all the bench members were happy and they were saying yes, basic structure doctrine should be applied. No. This judgment and this basic structural doctrine, it was pronounced by the support of, you can say, just one judge was in favor and rest, were in against of basic structure doctrine. It was a ratio of 6-5. So now you should question, then why other 5 judges were not in support of basic structure doctrine? My answer is, now this point need to be used in critical analyze kind of question. Because other judges were of the view that it is going to establish a wrong precedent. Because India is a democracy and Indians elect their representatives in Parliament, and these parliamentarians are having responsibility to become voice of the people and make laws for the people which are necessary. So this act of basic structure, which is not mentioned in Indian Constitution, would actually be like that we are not having any trust in parliamentarians. We are not having any trust in legislative pillar of Indian polity. So number 1 point was setting wrong precedent by which the message was giving, what the message communicated was that this legislative branch cannot be trusted, and that is why we want real power in our hand. Right? Second main point of its criticism was that it was a judicial invention. Judiciary itself was going beyond what is mentioned in Indian Constitution. And some legal luminaries, including the judges who were presenting their dissent, they were of the view that although basic structure doctrine seems fine, it is going to restrict unconstitutional amendments in future. But the point is that in future it is going to open a Pandora box by which future benches of Supreme Court might invent new kind of doctrines to increase the power of Supreme Court. So it means opening Pandora box by which Supreme Court in future might increase its own power. Point number 2. Point number 3 of criticism was that it is against the principle of balance between legislature, executive and judiciary. Because our division is based on check and balance. And check and balance means the other organs should also have this power to keep a check on the power of other pillar. Other pillar means in this case judiciary. So I hope now you are clear on what basis some points were raised against the basic structure doctrine as well. Okay, but please remember, in critical analyze question, when you are going to present your views, after that you are going to present some positive views as well. Okay, because you have to find a balance in this. Now, positive, what we are discussing. Now, challenge 25th Amendment Act. So 24th we discussed. In 24th, what Parliament did? Parliament amended Article 368. And they actually added subclause 4, subclause 5, by which they said that Parliament is having amendment power to amend any fundamental right, and which is going to be beyond judicial review. By 25th Amendment, they added Article 31C. Article 31C, what it says, we discussed it in DPSP, we discussed it in fundamental right, that any law which is made for upholding the principles mentioned in 39B, 39C, DPSPs, even if this law contravene Article 14, Article 19, yet this law will not be considered as null and void, right? Now, upheld validity of 24th and 25th, Parliament has power to amend fundamental right to implement DPSP. So, in this case, Kesavananda Bharati case, they said, okay, you have the power, happy. Not unlimited power, you have the power, but this power is not unlimited. It means amendment should not destroy the basic structure. And famous jurist or famous judge in Kesavananda Bharati bench, Mr. Khanna, he actually forced this doctrine. And I think now you're clear why I was saying in 1964 Justice Mudholkar actually was presenting his views like seed of basic structure doctrine, which was getting shaped in due time, and in Kesavananda Bharati case it was formally declared. Minerva Mills case, first provision of 39C, unconstitutional. Fundamental rights over DPSPs of state policy, means this debate was going on, means fundamental rights are superior. Fundamental rights conferred 1419 were accepted as subordinate to DPSP, specified in 39BC. This we have discussed in DPSP and FR part also. Article 31, right to property, was abolished. We discussed it. 44th Amendment Act, balance between fundamental rights and DPSP. This was the major contribution of Minerva Mills case. No more conflict. Let's have a balance. Both are necessary. Please remember, Supreme Court used one famous doctrine whom we call harmonious construction. So what is the meaning of harmonious construction? When two set of provisions are directly in conflict with each other, okay? For example, DPSP's FRs, who we should give more priority, right? So in this case, Supreme Court might find a way to bring a balance between these two provisions so that no one provision should be declared that it is not going to be applicable. Okay, so for upholding the sanctity, usefulness of both the provisions, a fine balance where workability of these provisions can be ensured is known as harmonious construction doctrine, which is used by Supreme Court in many cases, like in this case. Now, before we start this Indira Gandhi and Narain case, let's understand this debate. So in 1973, when Kesavananda Bharati case was telling that basic structure doctrine is there, so some jurists were of the view that it is going to set wrong precedent. It is going to set a precedent where we are not trusting the legislative branch, right? That was the opinion. I'm talking about 1973. Now in 1975 to 1977, what was happening in India? Emergency, right? So in 1975, what happened? That Indira Gandhi ji was facing a legal trouble in a case, Indira Gandhi versus Narain case. Narain, his opponent at that point of time, so he filed a case and he leveled these allegations that Indira Gandhi ji has used state machinery in her election process. So Allahabad High Court actually found that those allegations were true, and on this basis Allahabad High Court said, Indira Gandhi ji, now we declare that your election is null and void. It means you are not going to be considered as MP in Lok Sabha, and Indira Gandhi ji was Prime Minister. So Allahabad High Court said, and because we are saying that you are not going to be MP in Lok Sabha, now you should actually give up from your position. You should resign from your position as Prime Minister. And third point which they said, which Allahabad High Court said, is that you will not be fighting elections for next 6 years. So don't you think it was like a political murder of Indira Gandhi ji, right? But law should be supreme, right? Whoever done any wrong, law should be supreme and law should actually take its course. But what Indira Gandhi ji did? Indira Gandhi ji filed a case in Supreme Court against this judgment of Allahabad High Court, and it was accepted the same day. Obviously, Prime Minister is there. Now, Supreme Court gave interim bail, means no arrest will be done, right? But at this point, Indira Gandhiji was quite, disbalanced. What is going to happen if Supreme Court also gives judgment like Allahabad High Court did? Because Supreme Court said within 6 months, we are going to pronounce a judgment, and for 6 months, you can be on this position of Prime Minister. And why Supreme Court gave this logic? Because our constitution says that you can be on a position of minister, prime minister, but within 6 month period, you have to secure membership of any house. It means if you are a prime minister, you can be a prime minister, means I can be a prime minister of India. You never know what happens in future. And without fighting election, I can be prime minister of India. I just want majority MPs supporting me for the prime minister position in Lok Sabha. Okay. And within 6 months, I have to be part of either Lok Sabha and Rajya Sabha. So based on this logic, Supreme Court said, Madam, you can be, you can remain in this position, and we are going to pronounce a judgment within 6 months. But Indira Gandhi said, I have to do something. So she presented this this proposal to our president at that time, and emergency was imposed on the cause of this. There is this internal disturbance in India. So now, when this happened, and thereafter 39th Amendment Act and 42nd Amendment Act happened. So these amendments were like a shock for judiciary as well as other people. It was like Parliament was increasing its power in leaps and bounds, and just for saving Indira Gandhiji in this particular case. For example, in 39th Amendment Act, what Indira Gandhi did, she declared, she added this in constitution, that when it comes to election of president, vice president, appointment of prime minister, election of speaker, this particular election process will be beyond the purview of court, beyond the purview of review, beyond the purview of judicial review. So it was like election, appointment of prime minister will be beyond the purview of judicial review. Why she did that? To safeguard her position as Prime Minister of India. So some people said it is a legislative fraud on Indian Constitution. How can one leader, for securing her own position, change the Constitution? This is wrong. So now those judges who were having dissenting opinion in Kesavananda Bharati case in 1973 saw after 2 years what is happening in India. So now it is said that they were also getting some, notion, okay, it seems like basic structure doctrine was needed, so that some basic foundation can be safeguarded. You cannot trust legislative branch thoroughly, right? At least it was proved by these amendments. Now, Supreme Court applied the theory of basic structure and struck down clause 4 of Article 329A. 329A, which was talking about, this appointment of Prime Minister, election of President, Vice President, Speaker out of the purview of court. So, which was inserted by 39th Amendment 1975 on the ground that it was beyond the Parliament's ascending power to destroy the Constitution's basic feature. So now the basic structure doctrine came to use, right? 39 Amendment Act was passed by Parliament during emergency period. I've already explained election President, Vice President, Prime Minister, Speaker of Lok Sabha beyond the scrutiny of judiciary. Okay, I think the whole story is clear to you. This is just here written here so that you can read. Okay, and please remember, with the position of Prime Minister, we should not use the word election, because there is no provision of election for the position of Prime Minister in Indian Constitution. Prime Minister is appointed. Election is for the position of MP of Lok Sabha, right? Now, Waman Rao case, another important case. The Supreme Court again reiterated basic structure doctrine. Demarcation of what is the major contribution of Waman Rao case? The debate was going on that now we are clear basic structure doctrine is in place. But whether basic structure doctrine can be used to actually excavate into the history of Indian polity the cases which were made before, it means basic structure doctrine will be applicable on new laws, or it will be applicable in old laws also. can we actually file a case against some old law asking Supreme Court to check whether it is against basic structure doctrine or not? So in this confusion, so this confusion was cleared by Supreme Court in Waman Rao case, and Waman Rao case said that the date of Kesavananda Bharati case, 24th April 1973, will be demarcated as a line. So cases before that, means any law which was made before that, will not be judged under basic structure doctrine, but later cases will be, you can say, judged under basic structure doctrine, reviewed under basic structure doctrine. Okay, this was the major contribution. I hope this is clear to you, right? Why this was made up? Because before that, this ninth schedule was added in Indian Constitution. It was added by Mr. Jawaharlal Nehru, right, in his time, so that any law which is added in ninth schedule of Indian Constitution will be considered as beyond the purview of judiciary, right? Although judiciary later said, no, aisa nahi chalega. Even if you add something in ninth schedule, that is going to be part of judicial review, okay? But whether the laws which were added in 1951 can be reviewed under basic structure doctrine, answer is no, as per the judgment of Waman Rao case, okay? Only after 1973 laws will be reviewed. Okay, I hope it is clear. So the whole story which I explained to you is written here. Okay, you can read it as this PDF will be available to you in my Telegram group, Shashank Tyagi for you. Indra Sawhney versus Union of India. There also we saw the application. What you know about Indra Sawhney case? Famously for reservation policy. That reservation cannot go beyond 50%. And this creamy layer provision of 27% for OBCs was introduced in this particular case. But why we are reading Indra Sawhney case in basic structure doctrine? Because rule of law was added to the list of basic features of Indian Constitution. As I told you, in different cases, features were declared as basic structure. So in Indra Sawhney case, rule of law was declared as basic feature, or you can say part of basic structure. What is rule of law? It means law is supreme. No one is above law. Okay? SR Bommai case. Why you remember SR Bommai case? On stopping the misuse of Article 356 by Union to actually change the political, you can say, structure. You can say, means abused. Sometimes a party which is in center wants to actually change the government at the state level. So they have many times they have used SR Bommai. They've used Article 356. For example, you can search about Bhuta Singh case, the famous, or you can say infamous governor of Bihar who used Article 356 so many times, right? So now, why we are talking about this in basic structure doctrine? First, you should know that it was about curbing the blatant misuse of Article 356. So whenever a question is going to be asked on President rule and critical analysis, you should write SR Bommai case, right? But there was some detail here, and detail was that Union cannot abridge a particular protection which is there for states as given by our Constitution. It means federal feature are also there. So it means Supreme Court held that policies of state government directed against an element of the basic structure of Indian Constitution, this cannot happen. Okay, there should be a balance as ensured by Indian Constitution. Now, elements of the basic structure. So as I told you, elements of the basic structure are discussed, or you can say declared by Supreme Court on case-to-case basis. Some of the elements are here. For example, number 1, supremacy of the Constitution. Constitution is supreme. Number 2, sovereign democratic republic nature of Indian polity. There cannot be any amendment in Indian Constitution which compromise these features. Third, secular character of Indian Constitution. Fourth, separation of power between legislation and executive judiciary. Fifth, federal character of the Constitution, as I was telling you about this in SR Bommai case. Now, evolution of the basic structure doctrine. So there's a list in your Lakshmikant which gives different cases and how different provisions were given the status of basic structure doctrine. What you need to do? You just need to open your Lakshmikant, this list, and you need to go through. What kind of questions are asked from here? It can say which of the following is not considered as not considered as part of basic structure of Indian Constitution. So there will be 4 statements. They will ask which of the following is not. So you can only answer this question when you have gone through this list, although that's not a big task because you need not to cram this. You need to understand this constitution and logical evolution of Indian polity. Okay. So I hope this debate evolution is clear in your mind with respect to basic structure doctrine. So this PDF is going to be available in this Telegram group, Shashank Tyagi for you. I'm available for you on Telegram, Twitter, other social media platform as well. So if I can be of any help to resolve any of your doubt, I'll be more than happy to help you out. Keep learning, keep growing. Shashank Tyagi signing off.